Hello everyone, welcome to Courts Today by Live Law, your go-to source for the latest and fastest legal updates. I am your host Urvashi Chauhan, here to bring you daily developments, landmark judgments and significant rulings from the world of law. Let us begin with the headlines, and after that we can delve into the full details. The Supreme Court has upheld power of states to regulate industrial alcohol under the term intoxicating liquor. The Supreme Court has set aside NCLAT order which closed insolvency proceedings against Byjus based on a settlement with BCCI. The Supreme Court has deferred marital rape case hearing, citing improbability of decision before CJI Chandrachud's retirement. The Delhi Lieutenant Governor in an affidavit has told the Supreme Court that he was not informed of the need to take court's permission for cutting trees in the Delhi Ridge Forest. The Supreme Court has said that there will be no uprooting or transplantation of trees for Kolkata Metro Rail without permission of the centrally empowered committee. The top court has dismissed Swami Shradhanand's challenge to imposition of life sentence without remission on him for murder of his wife. The Supreme Court today remarked that the Environment Protection Act has been rendered toothless due to centre's inaction. A PIL has been filed in the Allahabad High Court to restrain Yati Narsinhanand from making remarks against Prophet Muhammad and the Holy Quran. While opposing PETA India's plea in the High Court, the state of Karnataka has said that Kambala Race is Karnataka's culture and cannot be limited to one particular region. Starting with an update from the Supreme Court. A 9-judge constitution bench of the top court today by 8:1 majority has held that states have the power to regulate denatured spirit or industrial alcohol. The 9-judge constitution bench comprised CJI Chandrachud, Justices Rishikesh Roy, Abhay S. Oak, B.V. Nagarathna, J.B. Pardiwala, Manoj Mishra, Ujjal Bhuya, Satish Chandra Sharma and Augustine George Massey. The court was essentially tasked to examine whether the Industries Development and Regulation Act gives complete regulatory power to the Union on the subject of industrial alcohol. The majority has held that the term intoxicating liquor in entry 8 of the state list of 7th schedule will include industrial alcohol. It said that the term intoxicating liquor cannot be interpreted narrowly to include only alcohol which is fit for human consumption. Liquids which contain alcohol, which can be used or misused for human consumption, can be included within this term. CJI Chandrachud, who wrote the judgment for the majority, stated that the term intoxicating can also be understood as poisonous. Liquor, which is not traditionally considered as alcohol, may be covered as intoxicating liquor within the meaning of entry 8 of list 2. The majority also took note of the public interest element of entry 8 as it seeks to control various stages ranging from the production, manufacture, possession, transport, purchase and sale of intoxicating liquors. Hence, the meaning of phrase intoxicating liquor cannot be limited to potable liquor, and it signifies all alcoholic liquids which can harm public health. Justice Nagarathna in her dissent held that industrial alcohol means alcohol which is not fit for human consumption. An artificial interpretation cannot be adopted to give a different meaning to the term intoxicating liquor, which is contrary to the intention of the framers of the Constitution. What is required is to be seen is nature of the product which leads to intoxicating effect in humans. It is only by direct consumption of alcohol. According to Justice Nagarathna, just because industrial alcohol can be diverted and misused for human consumption, the meaning of entry 8 list 2 cannot be stretched. To read the full judgment, you can visit livelaw.in. The Supreme Court has today delivered another judgment setting aside order of the National Company Law Appellate Tribunal, which had closed the insolvency proceedings against EdTech company Byjus. This was after the tribunal accepted a settlement between Byjus and the BCCI for about 158 crores. Byjus, a well-known Indian edtech company, faced financial difficulties following reopening of schools post-pandemic, which led to a decrease in demand for its online educational services. Byjus had a deal with BCCI to advertise on cricket team jerseys and get match tickets. They agreed to pay a certain amount for this. However, it failed to pay the full amount, owing 158 crores. Despite having a bank guarantee, they did not clear the debt, leading to financial troubles and legal action against them. In August, the Chennai bench of the NCLAT approved a settlement between Byjus and BCCI. This settlement, which involves payment of 158 crore in arrears, would allow Byjus to exit insolvency proceedings that were initiated due to a petition from the BCCI. US-based lender Glass Trust Company LLC objected to the settlement, suspecting that Byjus might use their loan funds to pay the settlement amount, essentially diverting their loans to pay off BCCI debts. The bench, led by CJI Chandrachud and comprising Justices J.B. Pardiwala and Manoj Mishra, held that the NCLAT erred in allowing the withdrawal of insolvency application by invoking its inherent powers, because when there is a specific procedure provided for withdrawal of insolvency applications, the NCLAT cannot invoke its inherent powers. The court also noted that as per regulations, the application for withdrawal has to be submitted by the interim resolution professional and not by parties themselves. It is the IRP who takes charge of the affairs of corporate debtor once an insolvency application is admitted. The court also stated that NCLT cannot be considered a post office that merely approves the application for withdrawal given by the parties. Also, in the present case, it was the appellate forum, that is the NCLAT, which approved the withdrawal and not the NCLT, which is a gross illegality. In the judgment, the court held that Appellate Glass Trust Company LLC is not an unrelated party, as its claims were verified. Hence, it has the locus to challenge the NCLAT order. At the same time, the Supreme Court refrained from entering a finding on the objections raised by them. The Supreme Court today deferred hearing of pleas seeking to criminalize marital rape, considering the fact that the matter is unlikely to be decided before retirement of Chief Justice of India D.Y. Chandrachud, who is presiding the bench which started hearing the matter on 17th October. Last week, senior advocates Karuna Nandi and Colin Gonsalves had presented the arguments. Today, senior advocate Gopal Sankara Narayan, who appears for another petitioner, said that he will take at least a day to complete his submissions. Similarly, S.G. Tushar Mehta, senior advocate Rakesh Dwivedi for the state of Maharashtra, and senior advocate Indra Jaisingh for a respondent wife also submitted that they would also require 1 day each to complete their submissions. Certain interveners for men's rights bodies also sought time to address the court. CJI Chandrachud noted that if the arguments cannot be completed this week, then it would be difficult to decide the matter before his retirement, which is happening on 10th November, as next week the court is closed for Diwali vacations. In view of this, the matter was adjourned and will now be posted before another bench for a fresh hearing. Let me also tell you that the petitioners here challenge exception 2 to section 375 of IPC and section 63 of the Bharatiya Nyaya Sanhita, which provide that sexual intercourse or sexual activity by a man with his wife does not amount to rape. The union, in its recent affidavit, opposed the court criminalizing marital rape. It stated that alternative remedies in law already exist to protect married women against sexual violence, and attracting the offense of rape to the institution of marriage may be excessively harsh and disproportionate. In the Delhi Ridge illegal tree felling matter, the chairperson of Delhi Development Authority and the Lieutenant Governor of Delhi, V.K. Saxena, has informed the Supreme Court in an affidavit that he was not made aware of the requirement to take permission from the Apex Court for clearing of ridge trees for a road widening project. The affidavit of the LG comes after the bench led by CJI Chandrachud passed an order seeking his response in the contempt case initiated by the court against the vice chairman of DDA over felling of about 1100 trees purportedly for widening of the road to Central Armed Police Forces Institute of Medical Sciences Hospital. Earlier this month, the court noted that the chairperson visited the site on 3rd February this year and ordered the road widening to be expedited. However, finding the records unclear, the court had requested clarification from the Lieutenant Governor. As per the affidavit filed now, it was only after the incident of illegal felling of trees that happened in February that the LG was informed in letter by the DDA Vice Chairman in June about the said development. The fact that court's permission was needed for felling was first informed to the LG in March when DDA proposed constitution of committee of experts in terms of the directions in the MC Mehta case. The detailed affidavit also mentions 3 officers of DDA responsible for instructing felling of the trees on their own accord. The affidavit states that for the project due care was taken to ensure the less number of trees in the ridge get affected. To know about this in detail, you can visit livelaw.in. In the next update, the Supreme Court today ordered the Central Empowered Committee under Ministry of Environment to examine the issue of felling and transplantation of trees for the Kolkata metro construction. Until then, no felling or transplantation of trees shall take place without the permission of the CEC. A 3-judge bench of Justices B.R. Gavai, K.V. Vishwanathan and Prashant Kumar Mishra is currently hearing an SLP challenging the order of the Calcutta High Court, which declined to halt the construction work for a metro station in Kolkata's Maidan area, the construction of which requires uprooting of around 700 trees in the area adjoining Victoria Memorial. Before the High Court, the present petitioner had sought to stop the Rail Vikas Nigam Limited from continuing its construction work and call for a review of the proposed project by independent experts. Senior advocate Jaideep Gupta emphasized that 923 trees are being uprooted without proper permission from authorities for the metro rail construction. He clarified that the petitioners are not against the metro project itself. Gupta pointed out that many of these trees are among the tallest and oldest in the area. While the Forest Department has only given permission to remove 29 trees, the rest are being classified under transplantation, moving them to a new location. He further argued that the High Court failed to consider that survival rate of transplanted trees is very low, which risks permanently losing free cover in the Maidan area. Also, Solicitor General Tushar Mehta for the Union vehemently opposed the petitioner and questioned its locus standi. As Gupta requested the court to establish a committee to examine the issue since no committee has looked into the issue, this was objected to by Mehta, who stated that the court would have to trust the authorities. The Supreme Court today dismissed a review petition filed by Swami Shradhanand alias Murli Manohar Mishra seeking reconsideration of a judgment which imposed on him a life sentence without remission for the murder of his wife Shakre Khalili. The 84-year-old self-styled godman has been in jail for about 30 years and claims that he is suffering from health issues. The trial court and the High Court had sentenced him to death, but the sentence was commuted by the Supreme Court in 2008 to one of imprisonment until death. Shradhanand argued inter alia that the sentence imposed on him was in some terms worse than the death sentence, considering it precluded him from seeing the light of the day until his death. He urged that the direction in the impugned judgment violated his fundamental rights. Counsel for the state and counsel for Khalili's one of the daughters from her first marriage objected to the press and arguments made on behalf of Shradhanand. They also appraised that Shradhanand has already made a representation for pardon before the President of India under Article 72 of the Constitution. A bench of Justices B.R. Gavai, Prashant Kumar Mishra and K.V. Vishwanathan ruled that even if the court has sentenced someone to life imprisonment as an alternative to the death penalty, the President and the Governor can still exercise their powers of pardon or reduction of sentence. As Shradhanand's lawyer informed the court that a request has already been made to the President of India, the court decided not to intervene in this case. A Supreme Court bench of Justices Abhay Oak, Ehsanuddin Amanullah and Augustine George Massey was hearing the MC Mehta case concerning air pollution in Delhi NCR today and specifically focusing on stubble burning in Punjab and Haryana. criticizing failure of both the states and the Commission for Air Quality Management to take penal action against violators. The court had last week summoned the Chief Secretaries of Punjab and Haryana. Justice Oak remarked that the Environment Protection Act had become toothless following the amendment to its Section 15, which replaced punishment for violation of the Act with penalties. Additional Solicitor General Aishwarya Bhati today submitted that the Commission has issued show-cause notices to officers of both Punjab and Haryana, including the Secretary of Environment, Additional Chief Secretary Agriculture, etc. But the court criticized the Commissioner of Air Quality Management for merely sending show-cause notices to officers that have violated its orders regarding stubble burning instead of prosecuting them under the Act. Justice Oak also pointed out that the procedure to impose penalties under the amended section had not been operationalized. The union government had failed to frame rules to support the section and appoint adjudicating officers to impose these penalties, leaving the law enforcement agencies powerless. ASG Bhati then assured that Section 15 of the Environment Protection Act would be fully operationalized within 10 days. The court has set a 2-week deadline for the Union of India to amend the rules and provide proper rates of environmental compensation. Apart from this, the court has directed centre as well as governments of NCR states to file compliance reports of court's earlier orders on other causes of pollution in Delhi. The matter has been listed for further hearing on 4th November now. A PIL plea has been moved before the Allahabad High Court to restrain controversial head priest Yati Narasimhanand of Dasna Devi Temple in Ghaziabad from raising questions against Prophet Muhammad and the Holy Quran. The PIL plea filed by 2 Mumbai residents also seeks removal of his recent hate speech wherein he allegedly made objectionable comments against Islam and Prophet Muhammad. The plea states that if immediate action is not taken against Narasimhanand, who is spreading a dangerous atmosphere worldwide, then all systems for our country and state will fail. It prays that he should be restrained from making disputed religious statements. The petitioners have also prayed for a direction to the state of Uttar Pradesh to take legal action against him since he is doing anti-national work. A PIL has been moved by People for Ethical Treatment of Animals, that is PETA India, against the bull race event Kambala in Bengaluru. It seeks a stay and to restrain the state government from issuing permission for holding bull races, whether styled as Kambala or otherwise anywhere outside of rural areas of Dakshina Kannada and Udupi districts, where it claims Kambala is held as part of tradition and culture. According to PETA India, state's decision to organize the race in Bengaluru by transporting animals to the capital city is purely for commercial reasons. The Karnataka government in this regard today told the High Court that Kambala is a cultural bull race of the entire state and any argument to limit the same to any particular region would be nipped in the bud. Advocate General Shashi Kiran Shetty for the state further argued that the question is whether it amounts to cruelty to the animals or not. She said that horses are imported from different countries and when horse races are done, they move from state to state. The AG further informed that the event is proposed to be held in November and not on 26th October as wrongly claimed by PETA based on news reports. It was further submitted that not even any permission is yet sought from the competent authority for holding such an event. As the AG sought time to file a counter affidavit, the division bench of Chief Justice N.V. Anjaria and Justice K.V. Arvind adjourned the hearing to 5th November. For more details on the cases mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Please do not forget to like, share and subscribe to our channel. You can support us by donating through the thanks button at the bottom of our videos or by becoming a member for just 89 rupees per month.